All right, so I want to try this again because when I did the screencast-o-matic earlier today, you could not hear it. So we are in week 6, chapter 9, appeals. It's a relatively short chapter, which is good because you need to start reviewing for your midterm, which is next week. Also, don't forget that you have a discussion board on the legal benefits and hardships of marriage, and you need to get that done as soon as possible so that you can get a comment in as well before the deadline. All right, so we're talking about appeals, and one of the things I love to test you on is who is allowed to appeal, and either party, winner or loser, is allowed to appeal. And this is something that the public is very confused about, and they just think it's the loser that's allowed to. But sometimes you win, but you're not really happy with what you won. Maybe you didn't get a big enough trophy, or you thought you should have gotten more money. Same thing in law. If somebody feels like they didn't get enough money, they can appeal. Or if they feel like they didn't win on a particular aspect of their case, they can appeal as well. Alright, so if you recall, we only get 15 minutes together on these screencast-o-matics, so I will be letting you do some of the PowerPoints on your own. But just to remind you from your reading that you need a party, if they want to appeal, needs to have a final verdict. So the trial court needs to have made a final decision, whether that's the judge making the final decision in a bench trial, or whether that's the jury coming back with the final verdict. All right, you can read that slide on your own. All right, moving on to this slide. So I want you to know and understand who an appellant and appellee is. An appellant is a person taking the lawsuit from the trial court and bringing it to an appellate court. Okay. Let's go ahead and look at the next few slides because it kind of makes it a little bit clearer. The plaintiff is not the same thing as the appellant always, and the defendant is not the same thing as the appellee. So you notice I didn't put equal signs between the two columns. The plaintiff can be the appellant if they're unhappy with what happened at the trial court. They can bring the case to the appellate court. At the same time, if the defendant's not happy, the defendant could also become the appellant. So this slide just shows you kind of what I'm talking about, that either the plaintiff or the defendant can become the appellant. And it's about 50-50 for the most part. All right, in order to have a trial at the appellate level, the appellate court needs to see the record of the trial court. And the appellate court is not a court of, initial impression, meaning that they're not really supposed to ask a lot of questions or look at new evidence. They're supposed to base their decision on the evidence that occurred at the trial court level. And if they do have questions, they typically have to send a request for information or a remand back to the trial court. Okay, so in order for either plaintiff or defendant to take the case from the trial court and bring it to the appellate court, they need to have an appellant's brief. And there's many different aspects to it, and it's longer than most of the briefs that you would see in trial court. And it starts with a title page, and then there's a statement of facts. And each one of the facts in the appellate brief has to be tied to the record from the trial court. So a fact from page whatever of the transcript of the trial court. Then the appellant needs to look at all the errors that the trial court made and point them out to the appellate court to say, hey, this is why the trial court's ruling was wrong. Next, the appellant needs to do a legal argument saying, hey, based on all these cases in other courts, appellate court, you should hold the way I want you to. And then finally, there's a short and succinct conclusion. So if the appellate court needs to skim everything else, they can come back down to the conclusion and see what this case is about. Okay, so once the appellant has prepared that, That has to be served on opposing party, which is the appellee. The appellee could be either plaintiff or defendant, whoever wasn't bringing the appeal. So we serve on the other party, and we call it filing when we send something to the court. So this is also another great exam question. All right. Typically, an appellate case is basically a trial on the paperwork, and there's not going to be this big long trial that we're all used to seeing, like on Court TV or Law and Order or any of the other myriad of TV shows on law. It's basically going to be mainly the appellate court judges look at the record, look at the appellate brief, and there might be a short, maybe 20 to 30-minute argument. All right, so what the heck can the appellate court do with that case after it's been sent to it from the trial court, the record from the trial court? So there's 4 different things that the appellate court can decide, and I love to test on these as well. The first one is the appellate court can affirm. You can go ahead and say, trial court, you made the right decision. We agree with you. Next, the appellate court could disagree, which is reverse the ruling of the trial court. Third is reverse in part, and this typically is about the amount of money that the trial court awarded. The appellate court could say, nope, trial court, that was too much money to give, and we think you should give a less amount. Now, remand is the hardest one to understand, and basically what it is it's, we don't have enough information to make a decision. We need to get more information for us, or you didn't follow the law correctly, and here's how you follow the law correctly. Here's some instructions on how to do it. Now go back and relook at your decision and come up with a different answer based on the law and the facts of the case. All right, so one of the goals that we have for this chapter is to define certiorari, which is a Latin term. And I just love the concept of certiorari. I wish it applied to me as an employee. But what it is it says that either a state Supreme Court or a U.S. Supreme Court can decide whether or not to hear a case. I mean, those of us have worked before. Wouldn't that be awesome if your boss said to you, hey, do you want to do this work or not? And you could say no. That would be so cool. But that's not how it works for us normal people who aren't Supreme Court justices. So, a Supreme Court can go ahead and grant certiorari, okay? It can decide to hear the case, and the Supreme Court can go ahead and rule however it seems fit, hopefully based on prior precedent, but often they hear cases of initial impression. And then there's also denying certiorari, which is, we're not going to hear the case, and whatever the lower court held is what's going to stay in place. Now, there is an important exception to certiorari. Death penalty cases cannot be denied being heard. They all pretty much have to be heard either at the state court, Supreme Court, or they have to be heard at the United States Supreme Court, depending on the type of case. And this is because we have the societal desire to try to make sure that if we are going to impose the death penalty, that that person is hopefully guilty of whatever they're charged of doing. Okay, so we've discussed appellate courts, and now we're going to discuss in a little bit more detail. State appellate court. We in California are part of the Ninth Circuit Court of Appeals. Let's look at the next slide, because the country is divided into different circuits in terms of Court of Appeals for federal district court. Now, if you go ahead and look at California, okay, up here, you've got the Eastern District of California, you've got the Northern District of California, You have the Southern District, which is like the San Diego area, and you have the Central District, which is Los Angeles and the surrounding areas. So we had mentioned this before, and I had showed you, I think in maybe PowerPoint slide for chapter 2, my mission to the Southern District of California and the Central District of California. And we talked about before how most attorneys will choose to do the lower half or the upper half of the state of California. And we have 4 district courts, which are trial courts in California, because we have such a high volume of people. Now, if you notice, Washington, they only have 2. Other states, such as Alaska, only have 1. Now, all together, all of these states are in the 9th Circuit Court of Appeal, okay? And the trial courts are kind of the dotted lines, if you will. District courts, and then all together, we all make up the 9th Circuit Court of Appeals. All right, so the United States Supreme Court is the final say, honestly, really either from a federal or a state perspective. And let's go ahead and look at that. I love to quiz you on the 2 different ways you can get to the United States Supreme Court, USSC, or a lot of people like to say SCOTUS. SCOTUS, I've heard it both ways, Supreme Court of the United States of America. All right, so federal district court, okay, district courts, if you recall, are these central, eastern, northern, southern, for instance, that we have here in California. And then it goes to the Federal Court of Appeals. In our case, this is all these states. And so that's the 9th Circuit Court of Appeals. And then it goes up to the United States Supreme Court. There is another way to get to the U.S. Supreme Court, and that is the state way. We've got the state Superior Court, which is the trial court. We have State Court of Appeals, which is not the same as the 9th Circuit. And then we have the State Supreme Court, who can then send cases to the United States Supreme Court. And we saw some of that happening with the gay marriage cases. Now, I hope you're reading your book, and especially the cases, because they're redacted and shortened, and they have really good, juicy stuff in them. In this case, it was that this person was claiming the judge was biased against him, but in reality, he was really doing that to kind of make the case go longer so he could get ready for trial, because he wasn't really ready for trial. All right, your book talks about creating a brief bank, but I'd like to point out that if you're going into law, it's a great idea to keep examples of all your different types of work. You might want to redact them if you show them to other people, but it's a great idea to have samples of your work so that if you need to do an interview or you're working as a paralegal and you forgot how to do something, you have examples that you can rely on in helping you to do it in the future. All right, so then we have the ethics from this chapter, and it's important to remember that when we legal research a case, we need to give both the positive and the negative cases to our boss so that our boss kind of knows what the likelihood of our client winning is, and you know, what cases are against us and what we need to overcome. Please don't forget that I pick out the chapter review questions that I want you to focus on, and this should also help you prepare for your midterm and final exam as well. As always, if you have questions, comments, concerns, please contact me. I'm here to help. All right, bye for now.